the Nigerian governors.
Good evening. Thank you for joining us for another edition of the program, The Nigerian Governors Live. My name is Atinuke Nuke, sitting in for the regular host, Aondona Ingia. In a split decision of 6 justices to 1, the Supreme Court on Friday, the 11th February 2022, nullified the Executive Order 10, initiated by President Muhammadu Buhari to grant financial autonomy to the state judiciary and legislature. The Apex Court held that Executive Order 10 was inconsistent with the 1999 Constitution and therefore unconstitutional, illegal, null and void, and of no effect whatsoever. Since then, opinions have been split as regards the judgment by the Supreme Court. Some see it as some sort of sabotage by the same judiciary for whom President Muhammadu Buhari seemed to be fighting for, while totally agreeing with the decision of the Apex Court. In the midst of all this, all governors may seem to further strengthen their hold on other arms of government. On the program today, we shall be looking at the topic, implication for state judiciary after declaration of the Executive Order 10 as illegal by the Supreme Court. We'll go on a quick break, and when we come back, we shall go straight into the discussion. Stay with us.
The Nigerian governors.
Welcome back. The program is the Nigerian Governors Live, coming to you live from Abuja. My guest on the program today to discuss the topic, implication for the state judiciary after the declaration of the Executive Order 10 as illegal by the Supreme Court. Mr. Ogala Osaka, a legal practitioner here in the nation's capital. You're welcome.
Thank you very much. It's a pleasure to be here today.
All right. Okay. So the question now is that what sense do you make of the judgments of the Supreme Court to nullify the executive order?
Okay, I mean, to fairly make sense of that judgment, you have to take a few steps back. You have to understand what an executive order is, why executive orders are made, and the exact nature of Executive Order 10. I'll just give you a brief recap. An executive order by its nature is a presidential directive to the public service in order to fundamentalize public policy. So we know this government, this is the 10th executive order, and this particular one was passed in order to encourage the liberation of the state legislative arms and the state judiciary by implementing financial autonomy. So generally speaking, a president under a federal presidential system of constitution like ours has powers to make an executive order vis-a-vis Section 5, subsection 1 and subsection 2 of the Constitution. So yes, it is legal for the president to make an executive order, but that order has to be consistent with the provisions of the Constitution in trying to enforce that, and it also has to be made in order to enforce a law of the National Assembly. Now, the specifics of this Order 10. The mischief Order 10 was trying to solve goes back to about 2017. In 2017, there was a 4th alteration to the Constitution. That alteration was made to grant financial autonomy as a way of restructuring to the state legislature and the state houses of assembly. Now, when that alteration to the Constitution was made in 2017, there was a lot of celebration and jubilation. We were of the idea that this is the restructuring we need. Even though that alteration was made and section 121 subsection 3 of the Constitution was altered, what we saw was that the state governors refused to comply with that. That order basically said, or that section basically said, that as a first line item, any monies accrued to the state judiciary or the state legislature must be paid directly to the heads of those courts without wasting time, as the governors do, withholding those monies and pressuring the state legislature's heads and the state judiciary heads. But what had happened was that the state governors refused to comply with that. In response, the presidency set up the Presidential Implementation Committee. This was set up, I believe, in December 2020. This was headed by the Minister of Justice and Attorney General of the Federation, Minister Malami. Now, that Presidential Implementation Committee was set up to see that the constitutional amendment, the constitutional alteration to grant financial autonomy to the state legislatives and state judiciaries was implemented. Now, as part of that Presidential Implementation Committee, Order 10 came from that. So Order 10 was an attempt by that committee to force the governors to obey the fourth alteration to the Constitution and grant financial autonomy to the state legislatures and the state judiciaries. Now, what happened was that when the Presidential Committee proposed this and the President signed Order 10, the governors thought this is excessive, this is an abuse of the powers of the presidency. And the governors, all 36 of them, approached the Supreme Court in its original jurisdiction. Ordinarily, these cases will start from the lower courts and work themselves up, but because of the nature of the case and the parties, being the 36 state attorney generals and the federal government, it initiated the original jurisdiction of the Supreme Court, and that case was brought by the governors. The case was basically challenging the validity of Order 10, as you have said, and also challenging that, okay, if you're saying that the federal government can impose punitive measures as against the state, then maybe the federal government should take the responsibilities of handling those state courts. Because under the Constitution, the state government is in charge of capital projects for the state courts. So what the state governors now argued in the Supreme Court was that, okay, Mr. President, if you're saying you're going to withhold funds for capital projects, maybe you should move that responsibility over to yourself. So that was the background of some of the issues that led to the Supreme Court decision, which came out on Friday, and which you have alluded to basically invalidates Order 10, as well as rejected the claims by the governors stipulating or suggesting that the capital expenditures for the court should be transferred to the federal government to pay. So in a sense, my understanding of the judgment of the Supreme Court, to answer your question, is this. One, the Supreme Court has made it clear that the rule of law and separation of powers trumps any positive gains or trying to implement the Constitution, which is the argument the presidency was trying to make. What the Supreme Court has said is that the federal government is different from the state government. The powers of the federal government are different from the state government. The federal government cannot superimpose and be looking into the court affairs and operations, which by the Constitution is the purview of the state governors. So that's the first point that stands out from the Supreme Court judgment, the separation of the powers between the federal government and the state government in reference to their affairs. The second point that stands out is this. It seems as if in Order 10, what the federal government tried to do was add punitive measures for governors that don't comply with releasing funds to the states. So what that provision says is that in the event a state governor fails to appropriate funds, which are first line items to the state judiciary or the state legislature, the Accountant General of the Federation would withhold appropriations and allocations to the state and make sure those things are done. So what the Supreme Court has also said was that it was wrong for the president to pass that initiative because the role of the executive is to implement and not make law. The Constitution had made the law and they had altered it to say that yes, the states must, as a first line item out of the Consolidated Revenue Fund, pay the state legislative heads and pay the state judicial heads. But what the presidency now did was to try and take that further and say, if you don't do that, in the event you state governors don't do that, we are going to withhold the money. So the Supreme Court has once said there's separation of powers between the federal and state, but there's also separation of powers horizontally. The executive is meant to implement, the legislative is meant to make law. The executive cannot, by Order 10, seem to be making law on behalf of the government. So I think those are the two salient points we will take from that decision of the Supreme Court.
All right. So what is expected of the federal government? That's what should the federal government do next? Okay.
So some of the criticisms of the federal government is that what they're asking the state governments to do, they haven't done themselves. So under Section 121, subsection 3 of the Constitution, the governors are supposed to, as a matter of urgency, pay the state houses and legislative houses. Okay, but there's also section 81 subsection 3 of the Constitution. That subsection also puts the burden on the federal government itself to make sure that the judicial workers, judges and whatnot, are paid as the same first line item. So one of the things the president can do, or the presidency can do, or the federal executive can do is introspective. Itself should try and follow the provisions in section 81 subsection 2, which also relate to remunerations and payments and allowances for this judicial staff. The president and the federal government itself has not even fully complied with that provision. So one of the things they can do is first of all comply with that. Another remedy that seems to have popped up from this conversation is as regards the powers of the state legislative. Now, what the Supreme Court has said was that, yes, the state governors have the powers to control the funds for the state, and it's a first line item, so they have to do that. Now, the judgment gives further grounds to a state legislative to exercise checks and balances on the state government, on the state executive government, which is one of the roles of separation of powers and checks and balances. So one of the other options available to, for example, a state legislature now is an impeachment option. Okay. So if your governor withholds your funding for the legislative house or withholds the funding for the judiciary, it's valid grounds for an impeachment process. So there's an extra avenue which has been created through this series of cases for actually getting results from state governors. So I think, one, the presidency can implement section 81 subsection 2 and ensure that payments are made on time to the National Judicial Council, which takes care of payments for the judges, one. And on the second one, I think the legislative houses of the states have an extra avenue to check state governors vis-a-vis using the impeachment process and the grounds that have been raised by this section 121, subsection 3.
All right, thank you very much. That was so detailed and insightful. So how emboldened do you think that the state governors will become if the judgments given, considering the speculations that these arms of government are at the mercies of governors?
Yeah, I mean, that is the reality of on ground. It goes without saying. We've heard of situations where speakers of the House are waiting on the governor in order to get funds to run the House. We heard of situations where chief judges of a state high court are waiting on a governor to get funds so that they can pay for diesel for courts, so that they can pay for staff for the court, so that they can pay for materials for the court to operate. That's an absurdity. That's an absurdity. It's important to have checks and balances between the separate arms of government. It's one of the fundamentals of our democratic system. Now, if I understand your question properly, you're trying to clarify how emboldened the state governments and what the state governors. It is not a good sign. I was reading other opinions and people were asking who's the winner, who's the loser. There's no winners here, there are no losers here. That's not true. From the cases, the governors are the clear winners. The governors have been able to maintain that the federal government cannot withhold their funds, even though they don't pay the state judiciary or the state legislatures. So it would seem on the surface of it that the governors are the main beneficiaries of this victory, and that in itself might be something that will embolden them to take further steps. I had earlier mentioned to you that one of the unspoken benefits that we seem to see here is that extra grounds have been given. The Supreme Court has been cleared to say or suggest that those funds which are appropriated to the state government from the federal government and are supposed to be sent to the state houses of assembly and the state judiciary, once those funds are not sent as a first line item, which is first before you start going back and forth about it, that's a breach of the Constitution. And a fundamental breach of the Constitution like that is grounds for impeachment of a governor. So if, for example, I was Speaker of a House of Assembly somewhere, and a governor has withdrawn my funds and feels emboldened and nothing will happen, it's actually valid grounds for impeachment. So that's an extra avenue of checks and balances I think legislative houses should explore in order to keep their governors in check.
Okay, so do you think this is largely part of the reason the judiciary is complaining of paucity of funds?
It's one of the many reasons. I mean, the judiciary salaries, I don't believe, has been moved in a while. So it's not just availability of funds, it's the amount when made available. If you look at other jurisdictions, for example, the judicial systems are set up, technology is used grossly. from even the courts in the UK and the courts in the US, whereas in Nigeria we still have judges writing with longhand, etc. So we have a ton of problems across, not just with funding, with the operations of the judiciary system and the staffing of the judiciary system, even the appointment of the judiciary system. So there are issues that go across as regards the judiciary. The National Judicial Council has done a lot, and in fact, if you look at Section 81, subsection 2, the obligation is for the federal government to transfer funds to the NJC, and from the NJC down to the heads of the court. The Judicial Council gets a little credit in that it's doing that to the best of its ability, even though that hasn't been fully done. So yes, there are issues as regards paucity of funds with the judiciary, but it's not even the biggest issue. The judiciary is overworked, they're underpaid, they're using archaic technology and methodologies, the prison systems are overrun as a byproduct of that. So it's a whole ecosystem that has several issues, and not just necessarily paucity of funds.
Okay, so just looking at the this whole charade of what would you prefer, or what do you think is the right?
I think if we have to be honest with ourselves, the real issue here is political will. Okay, so there are laws in place, both federal and at a state level, to ensure that the courts, the funding for the courts are made accessible to the courts. What we lack is the political will to implement those things. So the first starting point has to be the political will from the federal government and from the state government, both of them. Even though they are fighting each other here, they are both complicit of the same thing. Neither of them is fully paying and paying on time. So the first thing we need is the political will to implement the laws we already have in place. We have more than enough laws. The second thing I believe, in my own personal opinion, I think we need is more transparency and accountability across. So even when funds are transferred, do you know how much? Do you know when? You know, those things are things that improve the system generically. Once we start to implement those things and we start to implement more and more transparency and shine light on a lot of this budgetary and appropriation, it's the money. You have to follow the money.
Yeah.
Okay, so once we start to shine our focus on those things, naturally the process will begin to improve itself naturally. The third point I want to make here is, I think you mentioned this earlier, civil interaction.
Yeah.
Yourself, myself, the average Nigerian must be concerned about these things. These are things that affect them directly. These are the people that must ask questions. It's not only about social issues, political issues and democratic issues and civil discourse are things that the average Nigerian must concern ourselves more with. Where are the funds appropriated to the state? How much was given to my state? How much was given to my local government? What was it used for? And check each line item. These are civil duties all of us as Nigerians must be more proactive in. So I think if you combine a few of those things, I think those are solutions and ways we can move towards your point.
Okay, I'd ask you just one more. What direct impact would it have on the ordinary people?
I think the importance of the judiciary and the legislative, you can't overstate. I think the competition between each of them. So the Constitution is set up that the legislative, the executive, and the judiciary act as checks and balances on each other so that we have a more efficient system. I think for the average Nigerian, having an underfunded judiciary, you can't overstate the problems. We saw the strike by the judicial workers last year that shut down the courts. Everything from being arrested by the police and your bail process is affected. Things like investors. How can somebody want to bring money into an economy when you don't know where the courts work, when the judge won't come, when you can be in court for 15, 20 years? Or what about security? Issues like security, we talked about the police and arrest, are also affected by the judiciary. So when you have a judiciary that is not functional, it actually directly affects all Nigerians, not just in developing our democracy, but also economically and security-wise. So it's very paramount and important that we have a liberated and autonomous judiciary as well as legislative system.
Thank you very much.
Yes.
That was really detailed.
Should I give you final points?
Yes, please.
Okay, so
so what are your final points?
A friend of mine, they were having a discussion in Lagos about ways forward for a political discussion. And I think one of the critical things, his name is Gihan, one of the critical points he made was a tweet by Dr. Seuss. And he was basically saying all of us, including you, must be more and more active actively participating in the political and democratic process. Once we're all able to do that, these issues will become less and less, and they'll be more and more accountable across board. The other thing is we want to thank the Supreme Court. It was a very good judgment. The Supreme Court has clarified that the end does not justify the means. You can't say just because you want to liberate the courts, you're going to break the law. I think that's very important. Rule of law is primary, is premise. I remember when a couple years ago at the Nigerian Bar Association conference, I think in Lagos, and I don't remember whether it was the president who made the point that national security issues trumps rule of law. And the position is no, nothing trumps the rule of law. The rule of law is how we all live as a society. Even if you want to do good, the end does not justify the means. You must do it with due process and proper procedure.
So on the final note, what would be your remark in general about the executive order?
Okay, so I think the most important pointers we have to take from it is fundamentally the rule of law. What the Supreme Court has said is that it's not wrong to want to grant financial autonomy and restructuring vis-a-vis that, but you have to do it in the right way. You can't have an executive making laws. Executive is supposed to implement laws and not make laws. So it's important, even if you want to do something, you do it the right way. The end does not justify the means. I think the second point I had made earlier is as regards transparency and accountability. We need that across all arms of government. The other point I want to make very, very quickly is as regards the point the Supreme Court made about the dichotomy between the federal government and the state government also applies to the local government. So I want to encourage local government and local government officials to also sort of seek their independence. Their finances are supposed to be independent. Their operations are stipulated by the constitutions are independent of the state governments. None is an appendage of the other. There's the federal government, the state government, and the local government. I want to encourage local government officials and those that operate on that level to also start to think of their own offices as independent of the state governments and not an appendage. And I think the final point I want to make is that I want to encourage everybody to be more involved in the civil process, the democratic process and the political process. The more all of us are involved, the better the process will be all across.
All right, thank you very much for that detailed explanation. It reminds me of the saying that if wise people sit back, fools will rule. All right, that's Mr. Osaka Ogala on the Governor's Live today. Thank you for joining us. Please stay tuned, same time next week. I am Atinuke Nuke, standing in for Aondona Ingia. Bye for now.
The Nigerian governors.